Two provincial assemblies have till date not passed that resolution, KP and Sindh. But Sindh is in liaison with the Ministry of Law, I am told, to iron out certain issues. But the mere fact that these two provinces have not passed resolutions ought not to prevent the federal legislature to wait for those resolutions to be passed. The law can nonetheless be enacted, and it will be prevalent in the provinces of Punjab and Balochistan. And as and when the resolutions come, or the provinces may even adopt that federal law, which will have then a provincial application. So this is something that I leave with the federal government to ponder over, so that at least some step in the positive direction is taken. Why I have started my address with this issue is because I have returned yesterday from a global symposium on mediation. And it was felt that Pakistan is lagging behind. Nonetheless, we have made strides in making positive developments as far as mediation is concerned, but the enactment of this law ASAP is the need of the hour. As far as mediation is concerned, Pakistan's journey towards it, in actual fact, started in the year 2022. By 2022, Pakistan had the benefit of having the legislative framework from all the provinces for alternative dispute resolution focusing on mediation. In Islamabad, the law came in 2017. In Punjab, apparently, it was 2018 or 19. In Balochistan, it came in 2020. But the mere fact that it came in 2020 doesn't mean that they were lagging behind. I tell you that the numbers that were gathered by the Ministry of Law, the largest number of referrals to mediation have been in the province of Balochistan. The largest number of cases settled through through the process of mediation has been in the province of Balochistan. International donors such as UNDP are concentrating on Balochistan. It is a struggle to tell them, please come to the north as well. Because just like certain areas in Gilgit-Baltistan, Balochistan is now the flag bearer as far as settling disputes through mediation are concerned. There was also a talk of the imposition of costs. Yes, I have been an ardent supporter for that. But unfortunately, courts in Pakistan consider the imposition of costs as some sort of a punitive measure. It is not a punitive measure. The ultimate litigant who is successful in litigation, when he is compensated with award of costs, all that the court is doing is to give its rights to him. When granting relief that he has sought in a suit or denying in favor of the defendant and not awarding costs, the court is actually depriving the successful litigant his right. So what we need to do is to develop a change in the hearts and minds of the courts, that the mere award of costs is not a punishment. Yes, you can impose a punishment, but that will be in addition to the costs that are paid in compensation to the successful litigant. If the litigant before you is unscrupulous, if he's wasted public time, which is at a premium, by all means impose exemplary costs on him. But the actual costs are the rights. We in the Supreme Court are in the process of making amendments in the Supreme Court rules and orders of 2025 so that a secretariat for the taxation officer is established. Why not? All the Supreme Courts and the High Courts in developed and civilized countries have it. We should have it. I remember when I was doing internships abroad, there used to be a queue of people collecting all their receipts so that their costs could be updated. Their travel costs should be recompensed to them. As long as there is a legislative foundation set for this, you can then build on it. The practicalities can come later. We are also in the process in the Supreme Court of establishing a court-annexed mediation center with financial assistance from the UNDP. The Chief Justice was very reluctant in giving me the best space in the Supreme Court for this purpose. The mediation center has to be nice. It has to have a nice view. People have to come there and be comfortable. So I've taken the nicest view overlooking the Constitution Avenue. But why did I do that? In Turkey, we were taken to the Chamber of Commerce, and there were two mediation center rooms that we were shown. One had this beautiful view of the Bosphorus Sea, and one had a terrible view of, another building in front of it. And they said, for some odd reason, this room with a beautiful view ends up in having successful mediations. So a nice environment is very important. Also, what is very important is, Rahim Saab said that in the United Kingdom, there are not many mediators. Well, that is not the trouble in Pakistan. In Pakistan, we have a number of mediators. And these are experts in different fields. When being responsible for choosing lawyers to be trained as mediators, I had to bear in mind that they had to represent the entire spectrum of law, ranging from banking law, service laws, civil disputes, land disputes, and so on and so forth. But these mediators need to be referred more cases than they have at their hands. They are ready to do that. For that, the courts have to be willing to refer cases to mediation and must never think that by doing so, they are shying away from their primary responsibility of adjudication. Yes, you have to hold your nose while sitting as a judge in telling parties to mediate and give them a brief as to the benefits of mediation. Parties are reluctant, having paid lawyers, to pay fees for the mediators. I'm happy to know that some of the mediation centers have a policy to have pro bono mediations. And in order to encourage parties to go into mediation, what we have decided now is to train as many judges as mediators, and also the officials in the High Court and the Supreme Court who are law graduates, who will be willing to conduct mediation in their own pay scales. In the Supreme Court, we already have had 2 gentlemen trained as mediators. They are now accredited from the research cell. There is a training program being started by the Ministry of Law on Monday. 2 more are going to be trained. And by the end of this year, I hope to take the number to at least a dozen, so that parties who cannot afford to pay for the mediators are referred to the mediation center, which will be housed in the Supreme Court free of cost, for mediation to be conducted free of cost. I remember when Ms. Sara Tarod was appointed as a mediator, and she successfully mediated a case which went on for years on end. And then there was another case when we wanted to appoint a mediator, and my Chief Justice said, why not appoint her again? I said, no, sir, and I'm sorry for that. I said, no, sir, if you're going to appoint her, you will have to pay her. You cannot be expecting mediators to work pro bono. Yes, they can do it once, they can do it twice, but not in every other case. Because mediation, I tell you, is also a very lucrative part of the profession. when you will see that when cases are referred, commercial cases will be referred. And in the commercial cases, there is a very high stakes for the mediator. Abroad, especially in Singapore, there is a certain percentage of the settlement amount that is set aside for the mediator's payment. This will happen in Pakistan, and I'm very confident that it will. But we are at the nascent stage. Do remember, our journey has started in 2022. In Turkey, it started in the year 2013, and by 2022, they had 3 million cases decided through a process of mediation. 3 million is a lot. When asked this time, last week, that what is the number, they said it is 9 million. 9 million is a staggering figure to decide through a process of mediation. In Pakistan, the total number of cases, including in the Supreme Court and the High Court, is 1.82 million. That is a very large number for the number of judges that we have to humanly cater for. So therefore, the alternative dispute resolution mechanisms have to be adopted to address this issue. Before leaving the rostrum, there is one other aspect that needs to be discussed, which is the talk of mandatory mediation. We have to be very careful about it. There is a draft bill that I have had the sight of, prepared by the Ministry of Law, which has the effect of including Section 3A in our Alternative Dispute Resolution Act of 2017. And that schedule will list the laws or the types of cases that have to be mandatorily referred to mediation. We have to bear in mind that there are certain laws, like for example, the rent restriction ordinances, for example, family laws, for example, suits on negotiable instruments, and so on and so forth, which require the courts to resolve them expeditiously. By making referrals of these disputes to mediation can have a counterproductive effect. It may take longer than it would have taken for the courts to decide. So we have to be very careful that mediation, instead of becoming a time-saving device, does not become a time-consuming device. But yes, the experiment of mandatory mediation can start off with fewer laws, because we do have a large number of accredited mediators as lawyers and in different other professions, but the number is not so large to deal with mandatory mediation. So this is something over which I would like to caution the Ministry of Law, that if you intend making a list, please do not make it very long, and do not make it such that has the effect of mediation becoming a time-consuming device. Thank you so much.
Pakistan is now